Thank you to everyone for joining us today. Dr. Deborah Davis, President and co-founder of Environmental Health Trust, will be introducing the speakers for today's press conference.
We're delighted to have so many of you interested in this press conference today. We are going to update you on a really important new federal lawsuit filed in the U.S. District Court in Sacramento regarding cell towers and antennas near homes and across the Lake Tahoe region. But this case could be filed in many places throughout the world today. There are thousands of circumstances very much like this one. What's happening in Lake Tahoe is happening all over the country, in thousands of cities and towns. Towers and small cells are being built closer to humans than ever before in history. Most people do not appreciate that what 5G really means is to take the signals previously of 3G and 4G, that some of which have been miles away, and bring them right to outside your bedroom wall in some circumstances. Most people are not aware that research shows that current types of technology can damage human health and the environment. We're going to hear about the Lake Tahoe planning process, and we're going to come to understand that they have not done any environmental review, nor did they follow relevant federal laws that should have governed their activities. All of this was brought to our attention by the courageous work of Monica Eisenstecken and 3 environmental nonprofit organizations, the Tahoe Stewards, Tahoe for Safer Tech, and our own organization, Environmental Health Trust, of which I am the president. This suit is being filed against the Tahoe Regional Planning Agency for failing to do its job in a fair way, and against Verizon Wireless and the Tahoe Prosperity Center. We are asking to stop the proliferation of 5G now until more information has been obtained about its potential to affect the environment as well as public health. The lawsuit raises fundamental questions of fairness, including the Americans for Disabilities Act, because the Eisenstecken family itself has been affected. Monica Eisenstecken has sensitivity to electromagnetic radiation, and the Fair Housing Amendments and the Americans for Disabilities Act require that she be provided with reasonable accommodations because of her medical condition. That has not happened here. In addition, as you will hear from our distinguished group of attorneys today, this case involves the failure of this Regional Planning Commission to follow environmental laws that are relevant, as well as to follow the Administrative Procedures Act, which requires a serious consideration of the record. Instead, you will hear how that record has reflected a betrayal of the public trust rather than an obligation to follow suit on it. The case has made headlines, as indeed it should, and I'm here today with the South Lake Tahoe resident, Ms. Eisenstecken, who will tell her story, and she will be followed by attorneys in this case, Greg Lean, Robert Berg, and Julian Gresser. I now turn it over to Environmental Health Trust Executive Director, Theodora Scarrato.
Thank you. So we are going to start by hearing from Monica Eisenstecken, who's a lifelong resident of South Lake Tahoe, California. She lives with her 2 young boys, her husband and her father, and her home is located just 150 feet away from a proposed 112-foot Verizon cell tower. Over 30 mature trees have already been cut down in anticipation of the cell tower. Monica has medically diagnosed sensitivity to wireless radiation. She's a local hero and an environmental conservationist who has persevered for 2 years working on this issue to prevent big telecom companies from transforming the pristine Lake Tahoe region into a smart city without adequate environmental review. Thank you so much, Monica, for coming on to tell us your story.
Thank you, Dr. Davis and Theodora, for the introduction. And thank you to all of our listeners this evening for taking the time to learn about our critical landmark federal lawsuit. My name is Monica Eisenstecken. I'm a lifelong resident of South Lake Tahoe. I live with my elderly father, my husband, and my 2 young boys ages 8 and 9 years old. I'm here tonight for two main reasons: to tell you my story as we battle Verizon's application to install a 112-foot cell tower just 150 feet from my bedroom window, and to inspire you to stand tall when the telecom industry chooses your community to be another dumping ground for its unwanted wireless facilities. Soon, members of our team will discuss this cutting-edge legal strategies involved in our case, strategies that could create positive legal precedent for future telecom battles all across the nation as it relates to the Americans with Disability Act, the Fair Housing Amendments Act, and even the environmental consequences associated with wireless infrastructure deployments. I have personally invested a substantial amount of money, and we have received several generous donations from the community. If you wish to join us in our legal case, I believe that this could help your family too. In the chat, you will see a link to our website, Take Actions page, where you can make 100% tax-deductible contribution to support this cause. Our family alone can't keep this historic public interest litigation alive. We need your help to continue to press forward. So now let's dive into the thick of it. When I first learned about Verizon's cell tower proposal, I knew nothing about the telecom industry or about wireless radiation. So naturally, I started doing some research. I made phone calls to different expert organizations. I called doctors and lawyers and former telecom insiders to get a good grip of the wireless issue. I was shocked to learn about the tons of diseases, endpoints associated with exposure to wireless radiations that have been discussed in peer-reviewed scientific journals for decades: cancers, ADHD, infertility issues, DNA damage, and more. I remember thinking to myself, if the tower goes up, it's not going to help us, it's going to hurt us. My home, I will not be able to live in my home any longer. And the legacy that my dad wanted to leave behind will be no longer. My dad worked his entire life to build this legacy for his grandchildren. It'll all be taken away from us. When we first approached the city about our opposition to the proposed tower, they were very unfriendly and basically said it was a done deal and that there was nothing we could do. No matter what we did, it was like we were talking to a wall, pure apathy. When it came our turn to object to the project at public meetings, outside interest descendants from all corners of the telecom industry to advocate for the tower. They gave Verizon 90% of the time to speak and a packed room of concerned residents 10%. I knocked on every single person's door for 4 weeks throughout our area. We received over 4,000 signatures from concerned residents. They ignored everything that we presented. We had almost 5,000 peer-reviewed different pages of people writing letters and real estate letters and you name it. We had everything, and they just completely ignored everything. They treated us like we were the criminals. I was so scared. I kept having nightmares, and I still continue to have nightmares. I felt like a little kid again, looking at the open door, leading into my dark closet, just waiting for another monster to come out. Everything I once knew, all of it, was slipping through my fingers. Every day I thought, I have to fight this, but we'll go broke in the process. And I'm going to be able to afford to send my kids to college after paying all these legal fees. Is my dad going to have to work full time until he's 90 to cover the cost of this litigation? It all became too much, so I started packing. That was when my father looked at me in the eye and said, "No, Monica, we're not going to go anywhere. This is our home. We're going to keep fighting. We're going to fight. We're going to fight this. We will not be driven out of our home by Verizon. I built this for my legacy. This is where we belong." So we kept pressing forward. I scrambled to find lawyers and anyone who could help us, but things just kept looking more and more bleak. That was until I connected with the Environmental Health Trust and Americans for Safe Technology, two organizations who infused our lives with the energy and resources needed to revive the fight of our lives. Months later, while I was more hopeful than ever that we will save our home, I frequently find myself contemplating, how do these telecoms sleep at night? Honestly, how the heck do they even sleep at night? I guess the fancy mattresses and the 500 thread count silk sheets help, but seriously, these are my kids. These are all of our kids. This is my home. Would they allow their kids to get zapped 24/7 by a cell tower? Would they allow the value of their homes to go crushed up, but 20% or more, so that some rich guy at the opposite end of the basin could stream The Lion King on his smartphone? We have perfectly good coverage here. I have never had an issue making a phone call. We don't need this. We don't want this. I'm going to pass the baton on over to the next speaker, but before I do, we humbly ask you, please consider donating to help us keep up the good fight. In the chat, you will see a link of our website, Take Action page. You can make 100% tax-deductible contribution. Support this cause. I will leave with one final thought to Verizon and all of the other wireless telecommunication companies who don't give a damn if they drive us out of our home just to satisfy their corporate interests. Shame on you. To Verizon, AT&T, and T-Mobile investors and shareholders, beware. The science is clear. You are investing in the next tobacco. Thank you.
Thank you so much, Monica. I'm now going to introduce Greg Land, who's an environmental and land use attorney based in Lake Tahoe, California. He was a participant in the first presidential summit on the environment hosted by President Clinton and Vice President Al Gore. For the past 40 years, Greg has specialized in the environmental regulatory processes for the Lake Tahoe region, with an emphasis on the processes governed by the Tahoe Regional Planning Agency. He has been a frequent participant in litigation, regulatory negotiations, and battles over natural resources and the environment in the Sierras. Greg?
Thank you, Theodora. I think the question here is really, what's the mission of TRPA? What's it all about? We need to go back and look a little bit at the history. Really, TRPA is the result of the recognition of the need for a much higher standard of protection for the fragile environment at Tahoe. It took broad support across the political spectrum to achieve this, both in California, Nevada, and before Congress. It's interesting, as a side note, the support is so broad that it was really the brainchild of arch conservatives Ronald Reagan and Paul Laxalt to come up with the idea for a bi-state compact way back in 1969. In essence, TRPA is a federally created regulatory overlay over the entire Tahoe watershed, partly in Nevada, partly in California, of course. It was given more power in 1980 when a stronger amended compact was signed into law by Jimmy Carter. No sooner did they do that strengthening, they completely shut down Lake Tahoe to do the proper job of planning. There was a blanket moratorium on all new development imposed to achieve this. No new subdivisions. All developers were chased out of Tahoe. Even minor construction shut down in the 1980s, all in an abundance of caution not to harm Tahoe in any way until comprehensive studies and plans were done. So now, why is TRPA laying out the red carpet for anything and everything that telecoms want, when now we know that the impacts can be potentially catastrophic? I mean, they've done no studies and no planning at all. Now, in a kind of ironic twist of history, the provision in the TRPA compact that really nails this is Article 5G. That provision says no projects can be approved unless it can be shown by the latest scientific information available that no environmental degradation will occur. And this is measured by so-called thresholds. These are benchmarks and yardsticks to measure progress towards achieving protection of Tahoe, involving 178 standards in 9 categories: air quality, water quality, soils, you name it, all intended to identify the things that we need to protect and the threats to them. Well, but back in 1980, when these standards were created, there were no cell phones. There was no cellular system at all. So we have an institutional blind spot. TRPA gives itself its own report card every 5 years, but not once has it even mentioned the potential threats to the environment from microwaves. There's no plan, there's no study. Therefore, per Article 5G, there is no way that you can improve, at least under TRPA's own guidance and own rules, another wireless project. A total moratorium on new project must be imposed until the required comprehensive planning and study is accomplished. For the last year, the plaintiffs in this case have been demanding that TRPA follow its own rules, all to no avail. The TRPA board has refused to even discuss this, even when presented with binders full of information with peer-reviewed science. We were forced to use the public comment forum as the only way to get a message through them, only to be met with a brick wall of silence. So that said, TRPA is extremely vulnerable to our legal challenge. Their failure to follow their own rules is blatant. And because it's a federal creation, took an act of Congress, signature of the president, there is no FCC preemption. We're very likely to prevail on the merits in this case. Not only is there a political and legislative consensus that Tahoe deserves a higher standard, but the courts also normally tilt heavily in favor of protection of the environment at Lake Tahoe. When TRPA is challenged for failing to adequately protect Tahoe, they generally lose. In short, we have a great opportunity to create new precedent here that can have national significance. And we can talk more about that later. For now, let's just say TRPA has to do its job and hold the telecoms to a higher standard than, say, San Jose. Shouldn't be the same standard. That's what's happening now. We need safer alternatives to wireless, and we shouldn't prioritize telecom profits at the expense of Tahoe's fragile environment. Back to you, Theodora.
Thank you so much. Now I'm going to turn it over to Julian Gresser. Julian Gresser is an international attorney, professional negotiator, inventor, and recognized expert on East Asia. Between 1973 to 1982, he was twice Mitsubishi visiting professor at the Harvard Law School and a visiting professor at the MIT Program on Science, Technology, and Society. He advised many international companies during this period on legal and business issues involving Japan and China. Julian?
Julian. Yeah. Thank you very much, Theo. I'd like to begin really with this question, and it goes to what do we really understand as prosperity? What will bring us a more abundant life? And for whose benefit are we engaged, particularly in this case of involving the Tahoe region? Congress, as my colleague Greg Lien points out, recognized the unique treasure of the Tahoe region and established a protective regime in the form of an interstate compact to hold Tahoe really in a sacred trust for the nation and really for future generations. The compact clearly affirms this principle and requires a regional plan to safeguard and to protect the region. Moreover, the federal government clearly maintains its oversight presence in providing continuing funding, presence on the TRPA board as a non-voting member, and many other ways. Nowhere in the compact is there a blanket license to cut down the trees, mar the beauty of the forests, kill the plants and animals, pollute the lake, and endanger the residents by blanketing the region with cell towers. Our litigation seeks to uphold the compact and the regional plan and the applicable federal and state laws. We urge that the fiduciary body, the Tahoe Regional Planning Agency, is not absolved from following federal laws such as NEPA, the National Environmental Policy Act, the Historic Preservation Act, the Endangered Species Act, the Americans with Disabilities Act, the Fair Housing Act, and the Administrative Procedure Act, to name a few. The extensive federal involvement justifies description of the implementation of the regional plan as a major federal action. This is a term of art, as this term is defined and interpreted by the courts in NEPA case law, and also under the principles of the California Environmental Quality Act. Further, the Tahoe Regional Planning Authority and the telecom companies must provide, as Monica suggested, reasonable accommodation as required by the ADA and the FHAA for those residents, and we're really struck by the increasing number of residents who are either claiming that they have become ill from RFR exposure from these cell towers, or at least in an imminent fear that they will follow the path of others for themselves and their families, and are desperately seeking some way to prevent RFR contamination. The mission of our litigation is stark and clear. The TRPA, as Greg said, must pause, declare a moratorium, and prepare a comprehensive environmental impact analysis, including a detailed assessment of the risks, the costs, and this is a key point, the benefits of viable alternatives. Indeed, an immediate, available, safe, secure, environmentally protective, more cost-effective alternative already exists. And it's in the form of what we call wired broadband or optical fiber to the premises, FTTP. The TRPA has not carefully considered this option, which, I might add, California taxpayers have very likely already paid for, and I refer you to the Irregulators versus FCC case. So coming back to the initial question, how do we achieve a more abundant life, not just for ourselves, but for future generations? Who will benefit? There is a balanced solution. This is the essential point for the present controversy, and that is for the TRPA simply to follow the law. There's much wisdom in the protections of the Congress embodied in the compact, which, if scrupulously observed, will ensure true prosperity for the Tahoe region. Thank you very much. I turn it back to Theo.
Thank you so much. So now I'm going to turn to Robert Berg, who is a highly experienced class action lawyer. He's achieved hundreds of millions of dollars in recoveries for aggrieved consumers and investors over the past 30 years, litigating complex class actions in federal and state courts nationwide, and where he's represented plaintiffs in consumer fraud, securities, and antitrust cases. Bob has served as the sole lead or co-lead counsel for plaintiffs in many landmark securities and consumer class action cases. He spent many years successfully battling the major telecommunications companies in a nationwide class action against AT&T, alleging consumer fraud in connection with the sale of a top-selling business telephone system. Bob achieved the then largest settlement of a consumer class action in New Jersey, a settlement in which the court valued at over $90 million. He also obtained a $120 million settlement in a securities fraud action case against Just Dutch Telecom. So thank you so much for joining us today, Robert.
Good evening. I'm Bob Berg. I'm an attorney based in New York. I've been a litigator for the past 38 years. I worked my first 7 years for two of the largest law firms in the country, representing the interests of major corporations. That experience made me see the light, and I jumped ship. For the past 31 years, I fought for the little guy. Since 1990, I've been a plaintiff's class action lawyer, and I represent classes of consumers or investors who've been cheated by big companies. I've specialized, actually, over the past 30 years in suing big telecoms, and I've sued them on multiple occasions, and it's an interesting experience, and I know their ways. When I met Monica late last year, her David versus Goliath story fighting Verizon's attempt to install this unneeded and giant cell tower next to her house really hit a nerve, and I decided to join her legal team. This legal action presents a unique opportunity for a federal court to order a regional planning agency to consider the environmental concerns presented by the telecoms industry's relentless rollout of their cell towers and wireless infrastructure. Normally, cell towers and wireless infrastructure siting decisions are handled by local and municipal land use boards. In 1996, after extreme lobbying efforts by the telecom industry, Congress passed the Telecommunications Act, which contains a nefarious provision that forbids state and local governments, land use boards, and state and local courts from considering environmental concerns relating to wireless radiation when addressing telecom applications for cell towers and wireless facilities. That's why many times when local residents show up at their planning commissions or town board meetings to protest a telecom company's application to put up a cell tower 100 feet from their kids' elementary school, or a 5G antenna 20 feet outside their kid's bedroom window because they don't want their kids to be blasted with wireless radiation 24/7, the residents are often told, sorry, we're not allowed to consider health risks when we decide these wireless applications. However, this case is very different. Monica and the environmental group plaintiffs here have brought this federal action alleging violations of federal law. The provisions of the Telecommunications Act that prohibit discussions of environmental concerns relating to cell towers and wireless facilities simply don't apply to the main claims in this action. The Tahoe Regional Planning Agency is created by federal law, and its purpose is to conduct strict environmental reviews of all proposed projects, including cell towers and wireless infrastructure, to ensure that they meet the TRPA's very rigorous environmental criteria necessary to protect the Lake Tahoe Basin's pristine environment from degradation. But the TRPA has fallen down on the job in a big way. The TRPA has routinely rubber-stamped municipal decisions approving cell tower and wireless facility permits without conducting its own strict environmental review of the impact of the wireless radiation these facilities emit. In particular, the TRPA simply accepts as gospel that there's no detrimental environmental effect, so long as the wireless equipment is supposed to operate within FCC emission standards. The scientific community, however, has demonstrated in hundreds of peer-reviewed studies the harmful effects of wireless radiation to human health, to trees, to insect, and the environment. The TRPA utterly ignores such impacts on the Tahoe Basin's especially fragile environment. Moreover, the TRPA is required to consider the impact of each proposed project on the overall Tahoe regional plan that the TRPA prepares. But instead, the TRPA considers the cell tower and wireless facility proposals piecemeal, without addressing their cumulative effect on the entire Lake Tahoe Basin. This lawsuit calls the TRPA to task. We seek from the court an order enjoining the TRPA from issuing new cell tower and wireless facility permits until it follows its own procedures and ordinances and conducts the required strict environmental reviews. Further, Monica brings an individual claim under the Federal Americans with Disability Act and the Fair Housing Amendments Act. She suffers from hypersensitivity to wireless radiation, and if the Verizon cell tower is built 150 feet from her home, she won't be able to live there. Under the ADA and the FHAA, Monica is entitled to reasonable accommodation from the TRPA and Verizon, meaning that the cell tower should be installed at a location far enough from Monica's residence that it won't exacerbate her existing medical disability. This federal claim, which again raises environmental and health concerns relating to the siting of a cell tower, is also not preempted by the Telecommunications Act. So this lawsuit brings these environmental and health risks of wireless radiation to federal court, where they'll be litigated fully in public. Our litigation team is top-notch, aggressive, and committed to the case. We look forward to creating a landmark new law and protecting the Lake Tahoe Basin while fostering safe technology. Thank you very much. Thanks, Theodora.
Thank you so much. I'd like to start with some questions that have been sent to us. You also can put questions in the Q&A. So, and I'd like to add that Environmental Health Trust has written to the National Park Service, and this issue of installations in our wilderness is a critical issue. But the question that seems to be top of mind, we've gotten this in several different renditions, is how, given that Lake Tahoe and the Tahoe region has special federal protections, how does the precedent-setting nature of the case apply to other areas of the country? And why is this so important of a case?
Well, I think one thing we can certainly say is that there are a lot of other federal lands. The state of Nevada, for example, is made up of 80% federal lands. So if we're free of the FCC preemptions, Tahoe is really a great example of the work that really needs to be done in a much larger sense, really throughout everything that is controlled by the federal government. from coast to coast.
And also, if agencies are required to consider the scientific evidence of these environmental and health concerns, and that information is presented to courts, it'll be out there in the public domain and it'll be litigated fully. And as we expect, the information will get out there and courts will accept it, and we'll be able to show the serious impacts that are now pushed under the rug by the FCC.
I might add also that we've seen a pattern, particularly in the last administration over the last 4 years, in which the federal agencies, not just the FCC, but have been given a sort of carte blanche. The FCC is really the worst offender. And decisions that really are in violation of federal law are being permitted or have been permitted. And what the Administrative Procedures Act requires is most basic, is a record of reasoned decision-making and consultation with other agencies, which is entirely absent in this case. And so it's a test case really about a deeper issue of whether we're going to be a country of laws or really a sort of deep state administrative fiat. And it's really important that, as they say, there are a whole series of very clear, powerful federal laws clearly stated that are being violated. And all we're really asking for is that the TRPA follow the law, follow its own rules. This is not a revolutionary proposition. It's rather a simple one.
Thank you. Is there an opportunity to include other communities with similar situations, as you just discussed, to include them in this lawsuit, who are facing similar, cell towers being proposed? Can other communities join in?
Well, other communities within the Tahoe Basin certainly are affected and can certainly participate. Outside this basin, this is a unique area and operates under a unique federal law situation. So that's why we have particularly focused on Tahoe. But the lawsuit, we hope, certainly achieves goals that can be replicated elsewhere.
Yeah. I mean, I think the power of the case is it's very, very well focused. However, what we are creating is a template that can be applied by other concerned environmental groups in other situations, beginning with the other interstate compacts. I mean, we are in a way making interstate compact law as a distinct area of federal law.
Can you explain in more detail how this would create new law?
Well, I mean, there are a number of precedents that we mentioned that will be either that have already been established, but that we are reinforcing, and new precedents. To name just a few that we've already mentioned, the application of the federal laws to interstate compact, beginning with the National Environmental Policy Act. This is an area that we feel that there is strong precedent, but that we are really, particularly in regard to the extensive federal activities and having a ruling that this is a major, these piecemeal approvals together constitute a massive major federal action, will be an important legal precedent. Bob has already mentioned the precedents that we are relying upon on the basic fact that the ADA and the FHAA are not preempted by the Telecommunications Act of 1996 is already a precedent, but I think to reinforce it will be important. I think there's what's called a legal cultural aspect of this, which is also precedential, which is bringing together the deep concerns for the environment with also concerns about health and safety. These have been somewhat in our country split apart for a variety of reasons. But here you can see in Tahoe how how clearly they come together. They are part of an integral package, the integral framework, as I mentioned, which really goes to this deep question of how do we want to live? What is prosperity? What is a more abundant life for all of us? And I guess it all boils down to this issue of informed consent. We're not technophobes. We're not Luddites. We're not opposed abstractly to cell towers. We don't see the TPRA as as an evil organization or Verizon. But we're asking, what we see is a very balanced approach that recognizes the unique, the new treasure that Tahoe is about. And it seems to me that if a good part of the community really understands the issues and what is at stake, they will make an informed consent to support the pioneering work that Monica has actually begun.
Let me comment on the reasons why Environmental Health Trust got involved in this lawsuit. First, we were deeply moved by Monica's story and the fact that her father built this as the family's legacy, and they were being faced with losing this home that he had spent his life to create for them. It's a deeply moving story, and we're grateful to Monica and her family for telling it. But more importantly, as has been indicated, public lands are almost a third of this country, and there are several states, Nevada, Alaska, Colorado, Wyoming, where the majority of the state is public lands. And if we can establish this precedent to protect what is a public land, which has a unique historic role in society, that will be important. The question we have to ask ourselves is, what is wilderness? What are these protected areas all about? Is wilderness a place you need to go to play Pokemon Go? Or is wilderness a place for solitude and quiet and restoration of the soul? And if wilderness is to be protected, then the idea we should be blanketing the national parks with wireless has to be rethought and challenged at this time. And we hope, with the excellent attorneys gathered on this case and with others who are listening now this evening, that there will be more of a challenge to what's going on, and with the assumption that has been made that wireless microwave radiation is somehow not an air pollutant and should not be regulated. That assumption has to be challenged. And we look forward to working with all of you on that. And I hope you'll be able to support Monica and her efforts through this lawsuit, because it is hugely precedential.
Thank you. And so I put in the chat information that you can go to Tahoe for Safe Tech to learn more about the case. People are asking as well, what is the timeline for the lawsuit and what are the anticipated phases of this litigation?
Well, the lawsuit was filed at the end of November. We're expecting the defendants to move to dismiss the lawsuit for failure to state a claim. Their briefs are due in March, early March, and that process takes a number of months to finish the briefing. Then you have to wait for a decision from the judge. That can take between 3 months to a year, perhaps. And then we're fully expecting to win those motions to dismiss and proceed with the litigation. And then you get into discovery. These cases can take a couple of years to resolve themselves. Hopefully, once we win the motion to dismiss, the TRPA in particular will be motivated to resolve the case with us. But that remains to be seen.
I think there's also a possibility of a motion for summary judgment and perhaps a preliminary injunction.
Sure.
Because what the TRPA has done is such a blatant disregard of its own rules that there's almost no facts they could present to the contrary. So we do have a shot at a more truncated process.
That's true.
Thank you. How would you respond to someone who argues that we need cell towers for emergency services?
There already is a lot of cell coverage. There's about 120 or so cell towers in the Tahoe Basin already. And for emergency services, the first responders use their own radio towers, not cell towers generally. There's plenty of coverage in most areas there. What the wireless companies are trying to do in large part is to implement 5G and other small cell facilities as well. And that's really not for emergency coverage. That's so that they can stream their live videos and do all these other new data heavy type of transmissions. And in fact, what they should be doing is building out and completing their fiber optic networks in the basin. And there is already available in most of the basin fiber optic, which is faster, more secure, and is much safer from a health perspective. There's no wireless radiation involved, and it doesn't have the environmental and health impacts. And that's what they should be doing. And in fact, ratepayers have already paid for that. And the wireless companies owned, with Verizon, for instance, and AT&T, they have wireless divisions and landline divisions. And we paid for a build out that they never did. And they diverted all the monies in large part to building out their wireless facilities.
And just to briefly add to what you said so well, Bob, first responders and others already have something called FirstNet. They have it right in their SIM cards and their cell phones that they get priority over all other calls. So they're already pretty much covered.
Great. And so thank you. That answers some of the questions about how many cell towers are already in Lake Tahoe. So why has the Americans with Disabilities Act legal strategy not always been successful so far? I know that there are a lot of cases across the country, but what makes this different?
It hasn't been really tried in most places. It's being attempted in several places now for the first time. We think it's an excellent strategy to pursue, and it avoids the preemption argument where most people are stymied in, because most people who have raised these issues have done it in local government proceedings or in state court, and they find that they raise the health issues and they're thrown out of court, they're thrown out of the proceedings because they're preempted by the Telecom Act. When we have the ADA, for instance, there is no preemption there because it's another federal act and it's not preempted by the Supremacy Clause.
There's a particular, I might say, Ed, it's a particularly poignant aspect of the ADA as it applies in Tahoe, and that is the vulnerability of children. Children, we know, based on the scientific evidence, because of their growing brains and so forth, have a particular vulnerability. And the evidence that the Building Biology Institute and other organizations has uncovered is that children exposed to cell tower radiation have sleeplessness, have all sorts of anxiety, are nausea, have learning disabilities, and so forth. And in Tahoe, we've learned that the middle school has 2 macro towers right on its own. I guess it's in the baseball field. These are issues that have just been sort of ignored in Tahoe. And the Americans with Disabilities Act, many of these children have learning disabilities irrespective of their exposure, have other serious issues, autism and the like. Children with pre-existing conditions, put aside the exposure, should not be exposed. Each one of these children and their parents have potential rights under the Americans with Disabilities Act to ask for reasonable accommodation. This is a key word, reasonable accommodation, which means in many cases moving the tower away. If it's on school property, the school has an absolute right to say, move the tower so it's not exposing not just our children, but the teachers, the staff, and so forth.
Thank you. How do you think the TRPA is going to respond to your lawsuit?
Well, we hope they'll welcome it. Really, I mean, in a way, we're giving them, how can we say, we're giving them a mantle to do the right thing, to follow the law. We also, Monica, bless her heart, I mean, she has put so much effort into developing the environmental record. She's already submitted a very detailed assessment of the assets, the environmental assets the trees, the specially sensitive plants, the aesthetic aspect of it, and so forth. We've done a lot of work for the TRPA already. And so if they would work with us in a spirit of partnership, I think that it will help them achieve their mandate, that as the community itself really studies the issues that we've set forth, will welcome. There really is a path forward, I think, that can benefit everybody. And you say, well, what about the telecoms? Well, the telecoms have an opportunity to innovate. As was pointed out, many of these telecoms have optical fiber divisions. They rely on an optical fiber backhaul. There may be a really interesting opportunity to innovate in this area, to bring true prosperity for the Tahoe region.
Thank you. There are a lot of questions from people who have cell towers directly in front of their homes, who want to know if they can get involved and if they can join the case. And I know that that's dependent, because Lake Tahoe is a unique area. That isn't necessarily the case, right? People
Right.
cannot get involved.
This is a case that involves only the Lake Tahoe Basin, and we're trying to establish precedent that can be used outside of the basin later, but this case is really focused entirely on the unique aspects of the Tahoe Basin and the law that governs the basin.
Have there been other lawsuits in this area, in the basin, that are important to understand in relationship to this case?
There's another pending lawsuit in the basin regarding a cell tower.
Yeah, but this is a good question for Greg, because there has been a history of moratoria involved. Greg, maybe you could help elucidate that point.
Yeah, I was just going to weigh in on that. We've got one other case, the Garmong versus TRPA case that's on the Nevada side. So we have parallel cases on both sides of the state line. But one of the things that I think is significant is that it's baked into TRPA's DNA since way back in the 80s, when everything was so violently shut down, litigation flying around back and forth. And under the leadership of their then executive director, they really took the bull by the horns and decided to mediate this out and try to bring parties together towards a reasonable approach, which of course is just what we're asking. TRPA's current executive director, I think, has extended that tradition. I would cautiously hope that TRPA's leadership would again engage in what they're very good at doing, which is being proactive and getting involved, understanding what the views the various stakeholders are, studying it, understanding the science, and beginning to get proactive about following their own rules. So we hope that's one of the responses to our lawsuit.
Thank you. I'm reading a question. How do I find out if a cell tower, other wireless infrastructure is going to be installed near me? And there are a couple questions from people who are just learning about this case and the issue.
You have to read the public notices of hearings in your community. The cell tower companies are they try to keep these things under the radar as much as possible. And they try to give the latest notice possible, which is often just a week before the hearing, so that public opposition can't build up and that as few people know about these applications as possible. That's what we found over the last year or so that I've been involved in monitoring these situations. So you really have to look out in your community. Check out the land use boards to see. Planning commissions typically are involved in these decisions. See what their agendas are. It takes you just a couple of minutes every 2 weeks or so, whenever they meet in advance, to look at their agenda and see what type of applications. Call your town clerk or your city clerk and find out what's happening. Ask them, are there any applications pending for cell towers? There's a very short shot clock that has to be followed by once an application is filed, and the municipality has to respond with a yay or nay decision. So you can call up your town clerk and see what's going on and be involved. You have to. Otherwise, once the installation starts, it's kind of too late and you're really behind the 8 ball. You got to be in front of these things, and then you can act and you can prevent them oftentimes. Otherwise, it's really tough.
Ben, I would encourage Ben Levi to put the link to the map. It's a public resource so that you can see how many towers have been built in your neighborhood. Ben will put the link in so everybody can easily assess it. It's very, as they say, a single picture does what 1,000 words takes. And if you see how rapidly the Tahoe region is already being blanketed, it will shock you.
Thank you. And sometimes, you know, it doesn't even say cell tower. It says wireless facilities, as is pointed out in the chat by Courtney. Thank you. So it's really, most people are unaware when these are being proposed until they start to be erected in front of our homes.
Yeah.
I wanted
Ben,
to ask,
can I just say to Theodore, Ben has just put up for everybody antennasearch.com, and that can show you antennas and cell towers are within a couple miles of any address, your address. So I think that's a very, very useful resource that we've referred to in our
Right.
case.
and really there should be maps of the proposed towers as well, and transparency in what the radio frequency radiation levels are near homes pre and post also, which is something our country doesn't prioritize yet. But many other countries will actually have maps with radio frequency radiation measurements that are online for the public in real time radiation monitoring that happens. I had a question. The critical interplay between sections 332C7A and 332C7B of the Telecommunications Act of 1996 is often ignored by municipalities when reviewing applications. 332C7A provides municipalities with many powers to control installations of wireless devices that can override the limitations in 332C7B, which carriers enjoy focusing on. Is there ever any evidence that municipalities are neglecting their duty to the public in exchange for the revenues they collect from wireless carriers? For example, protecting the right-of-way, avoiding non-compatible uses of residential properties, etc.
The municipalities are limited now in the revenues that they can collect for the wireless installations, and they're up in arms about it. And the League of Cities and Municipalities has filed, has joined the suit to try to overturn the limitations on the fees that they can charge. But it's not a moneymaker anymore for cities and towns. They're restricted to very low fees. They can only recoup basically their costs for approving permit applications and the like, and they can charge like $200 for a small cell tower. It's really bad for them. So they're not really trying to put towers in because of the benefits they're getting monetarily from these installations. However, they're intimidated in many cases by the threat of litigation from the telecoms, and the telecoms tell them you can't object to these things on the basis of environmental concerns, and that's what they tell their residents. We can't fight these things, sorry. But in fact, they can on many grounds fight the installations if they don't like it. They do have aesthetic grounds, they have historic preservation grounds. They can try to move these installations to non-residential areas. They can control plenty of things. They often are intimidated by the telecoms from exercising those powers. And if they choose to deny an application for good reason and they get sued, so what? It's really, they're always threatened, look, you're gonna have to pay the attorney's fees, for instance, from the telecoms. That's not true. There's a lot of misinformation that are used in intimidating the local governments, and that's a problem too.
I just wanted to say once again, thank you for all the support that we received. I never imagined that we would gain this much, support. And, I went through 2 years of just not knowing what to do and wanted to go hide, in a hole basically, and just run away somewhere safe. And you know, it's a difficult situation and it's cost us a substantial amount of money. But what I would tell people is don't give up, keep fighting, reach out to people. There are people out there that will help. And we're building, you know, a nice large group of people that are becoming more aware, keep spreading the word and find the facts. Don't look at information that's captured or anything like that. Look between the lines, find the right information, because we're protecting not only our children, our families, our future generations, the animals, the wildlife, the people, the environment, the, you know, Lake Tahoe, everywhere around the world, not just Lake Tahoe, but we have to protect our earth and we have to keep fighting. It is worth the fight and we've got to stick together and stay strong. Thank you, everybody.
Thank you so much for joining us today. You can go to tahoeforsafertech.org to stay updated on the case. Be sure to sign up for their mailing list. We appreciate all of your support. Thank you.